morning, Mr. Anderson. My name is Sarah Bint Sharif, and I have been instructed by your solicitors for this today's conference, and I will be representing you throughout the case in court. Mr. Anderson, I can understand that it must be very hard for you because it is the first time you're facing prosecution. But it is very important for you to cooperate with me today, and so that I can give you the best possible advice. All right?
Yeah.
So the purpose of today's conference is to advise you on the evidence that we have and on your plea. And later on, based on whatever you tell me, I will advise you on the sentencing. So I have reviewed your case brief and I have a few questions to ask, and I want you to answer those questions properly so that I can give you the best possible advice. Do you have any questions so far?
So far, no.
Okay, so shall we proceed?
Yes.
All right. Mr. Anderson, have you met the complainant before this incident? I am aware about the sarcastic clap that the complainant made. So, what do you have to say about that? How did it make you feel?
Just wondered what his problem was.
Sorry, could you please speak louder?
I just wondered what his problem was, why he was doing it.
So, could you please tell me about the speed of your car when you were approaching the complainant's car?
I certainly wasn't speeding because I never speed. Consider myself a good and considerate driver. I was coming along the road and I saw this car trying to do a three-pointer, so I slowed down and stopped.
And did you give the complainant enough room?
Yeah.
Who got out of the car first?
He did.
And what conversation did you have with him that day?
He kept shouting, you could see what I was trying to do, you could see what I was trying to do. And I said to him, what's your problem? I gave you enough room.
So both the complainant and his mother, who was there that day, said that you said, "What are you going to do about it?" Did you say that?
No.
How and when the fight began? Could you please explain to me?
He was getting up in my face saying, you could see what I was trying to do, you see what I was trying to do. And I was, as I said, I just said, what's your problem? I gave you enough room. And then his mother, got the woman I didn't know was his mother then, she got in between us and she ushered him back to his car. And then he said, oh, go back to your car, little boy, or something. And I said, oh, don't give it that, mate. And then he was going back to his car, and I said, oh, yeah, I thought so. And then the next thing I knew, he pushed past his mother and he punched me.
So he hit you first.
Yeah.
And in response to that, what did you do?
I hit him back.
How did you hit him?
I punched him in the face.
And how many times?
Once.
So the complainant said that you punched him twice. What do you have to say about that?
That's not true.
Okay, so after the punch, how did he react?
He launched himself at me. Sort of, it was like a rugby tackle sort of thing, and was punching me in the ribs.
Could you please explain me the rugby tackle thing you just said?
He grabbed hold of me.
Okay, so he said that you had him in a headlock. Could you please give me
That's
more
not true.
information? That's not true. That didn't happen.
No.
So do you think that the punch you punched him, right? So was that proportionate?
Don't know what that means.
So he punched you,
Yeah.
he hit you, and then you punched him back.
Yeah.
Was that proportionate? Did you use the same amount of force, or why did you think it was necessary to punch him back?
He hit me.
So, okay, I understood. So, could you please tell me how you and the complainant ended up in the fence?
He grabbed hold of me and he was hitting me, and I was hitting, trying to get him off me because he wouldn't let go of me. And then I think the woman got involved as well. And then eventually we lost our balance and fell through a fence into a garden.
So the woman you're mentioning, it's the complainant's mother who was present that day during that time.
Who was what, pregnant, did you say?
No, she's the complainant's mother.
And you said she was something that day.
She was present that
Oh,
day.
present.
Yes. So she was present that day during the fight and she was trying to stop, according to her. And she said that someone punched her in the face. Did you punch her?
No.
Did you see who punched her?
No.
Okay. So there was one person with you, James. So where was he during this incident?
I think he was standing by the car.
And why didn't he come and help you or do anything to stop the fight?
I don't know, maybe he was better than I just didn't want to get involved.
You mentioned in the evidence that the complainant was trying to damage your car.
Yes.
Could you explain how?
He kicked the rear passenger side wheel hub, which dented it, and then he came and he pulled on the windscreen wipers and he bent them, and then he was pulling on the wing mirror of the driver's side and my side of the car.
Did that happen when you got back to the car?
Yes.
Okay, so you were in the car and the complainant was damaging your car.
Yes.
There is something else about the damages, the backside of your car. So could you please tell me how did that happen?
He just said he was kicking the passenger rear side wheel hub.
So did he do that first or the
Yes.
Okay, and then he came in front and
Pulled on the windscreen wipers and bent them.
okay, so what did he do after that?
When he started to pull on my wing mirror, I drove away because he was damaging my car and it was expensive and I've looked after it.
Did you tell him to stop or did you warn him?
Beat the horn.
He didn't stop after that.
No. If I plead guilty to the offence at the first hearing, will I be sentenced today?
So it is totally up to the court. When you plead guilty in the first appearance, then the court will proceed to sentence. It can be today, it can be in another separate hearing. The court has to decide it.
Okay.
Okay. So I have few more questions if you could answer, and then we will move to the advice. So when you got back in the car,
Yeah.
according to the complainant, you revved the engine. Did you start the engine immediately?
Don't remember now, but I didn't rev the engine.
You didn't.
No.
And did you click the complainant with your wing mirror?
No, he was pulling on the wing mirror when I drove off.
When you drove off, did you hit the complainant? Did you see that he fell on the floor, on the road, and became unconscious?
Well, he did some sort of dramatic fall onto the floor, yeah. It's all that.
You saw that?
Yes.
You didn't stop that time?
No.
During all these were happening, did you see that there was a 3-year-old kid present in the complainant's car?
No.
You didn't see any kid?
No.
And you mentioned that he also hit you. So why didn't you report it to the police, Ms. Anderson?
I was going to report it to the police later, but then I didn't get around to it. And then before I had a chance to, they called me and asked me to go down to the station.
Okay. So during the interview, you mentioned something about the complainant's separation with his wife and then his anger issues. So I would just want to know, how would you find those information?
Just something I heard in the grapevine.
And I'm aware that you have no previous convictions.
No, I don't. Will the jury hear about my lack of previous convictions?
Yes. So I will ask the judge to give a good character direction to the jury.
Okay.
So it means that he will tell the jury that you have no previous convictions, and that is actually a strength for our case.
And what about Tom Banks? What if Tom Banks has previous convictions? I mean, how do I get? Maybe he might be a criminal mastermind after all.
Yes, he may be, but he's a non-defendant. Okay, in this case, he's not the defendant. It is very hard to adduce evidence against bad character evidence against a non-defendant. So it is very unlikely that the judge would adduce evidence against him.
Right.
All right.
Yeah.
Mr. Anderson, now I'm going to tell you about the offense so that you have an idea. So you are charged with assault occasioning actual bodily harm, contrary to section 47 of the Offenses Against the Persons Act 1861. I would just describe you in simple terms so that you understand it. So the offense is committed when someone intentionally or recklessly attacks another person, and the prosecution must show that the attack directly caused the harm. Bodily harm means that the injury that affects the victim's health or comfort. The injury doesn't need to be permanent, but it must be more than minor or short lived. Okay? So the prosecution needs to prove that someone was unlawfully hit or force was used against someone. All right? So I appreciate that the defense that you have raised is self defense. You hit him back because you felt attacked. So now I will explain you the prosecution case, and I will give you an idea about what the prosecution witnesses will have to say in the court.
Okay.
Okay. So the main complainant is Mr. Tom Banks. According to him, you did not slow down until you got very close to his car, and you shouted something at him, which he couldn't actually hear. And you stopped the car, got out first, and walked towards him. And you were very aggressive. You grabbed the left shoulder of his jacket and spun him around. And then you punched him in his left eye twice. And you hit him in the ribs, and you hit him with your wing mirror. There would be another prosecution witness. It is his mother. She was present that day. She confirmed that you did not stop the car until you came very close to his car. And then you came out of the car and walked fast towards the defendant. And you punched him, you punched the complainant in the face once. And you had the complainant in a headlock. And I told you she felt a punch on her face. She will also try to say that it was you who punched her. And she saw that the complainant flew away as you hit him with his car. There would be another witness, which is PC Hannah Thornberry. So after the incident, he went to check your car, and she confirmed that the windscreen wipers were raised off the front of the vehicle and damaged, and to also confirm that the rear near side wheel arch was damaged. So I'm aware that you complied with the interviewing officer during the interview. You answered all the questions. So the jury won't be able to draw any adverse inference from it. Okay?
What does that mean?
So when you give no comment interview, then the jury will get a chance to think that this person is not answering the questions. That means he is guilty.
Okay.
But you answered all the questions, which means they have no chance to draw any adverse inference. Because if a person is not guilty, he would answer. He would say that he's not guilty, right? So, Mr. Anderson, in summary, I would say that the prosecution case is a strong one because they have two witnesses and they are ready to give the evidence. However, in from our side, there is no witnesses present. Okay, but things may change if the person James, who was present during that day, who witnessed the entire incident, if he wants to give evidence, then things may change.
Okay.
Okay. So, do you have any questions so far?
No.
All right. So I'm going to proceed. See, Mr. Anderson, I would advise you to plead not guilty because you have a defense of self defense. Okay, so if you haven't committed any offense, then you shouldn't plead guilty.
Okay.
So that would be my advice. Mr.
I
Anderson,
think that I think they know that he knows that he's in the wrong. He's not going to come to court anyway, so what's really not guilty?
you think that the prosecution won't be present in the court?
Well, I think he knows he's in the wrong, and I don't think you come to court.
See, Mr. Anderson, normally the prosecution comes in the court, even if they say that they won't. Okay, and if he doesn't come to the court, the judge will continue the trial. It is highly likely that the trial would proceed or the hearing would without, and he must have a good reason not to be present in the court. All right. Mr. Anderson, I have got to explain to you the concept of credit. So, what effectively the law says is that if you plead guilty at an early stage in your proceedings, you'll get the full credit, which is one third discount in your sentence.
Right.
So now, Mr. Anderson, today is your first hearing. If you plead guilty today, then you will get one third discount. And during the next hearing, which there's a high chance that it will be in the Crown Court, I will explain to you why later on. So if you plead guilty in the next hearing, then you will get one fourth discount. And then if you plead guilty during the trial, then you would get 10% reduction in your sentences. Okay? The reason why credit is given, Mr. Anderson, is because the judge recognizes that you have accepted responsibility for your wrongdoing and you save everyone time and money. Okay. So, Mr. Anderson, I have advised you to plead not guilty. However, it's just that the law requires me to explain to you this. All right. So, Mr. Anderson, I would just like to remind you that plea is a matter for you, and my role is just to advise you. Okay, it is completely up to you. It is your decision. So, Mr. Anderson, I will tell you about the sentences now. So, if you enter a guilty plea or you are convicted today after trial, then the court will apply the sentencing council guidelines for assault occasioning actual bodily harm. And sentences are determined by looking at harm and culpability. So, harm is about the damage or loss the victim has suffered, and culpability is about how much responsibility the offender has for the crime. So, I think the likely category would be 1B, which I'm going to explain you now. So, it would be a medium culpability because we don't have any medical evidence right now. And
There was only
uh,
there's only a little cut, he was hardly bleeding.
yes, but we don't have any medical evidence at this moment. Okay, and it is a category one offense, category one harm, and the starting point would be 1 year, 6 months custody. Okay, and the range would be from 36 weeks to 2 years, 6 months custody. And as I have already asked you about it, that if you have seen any child present in the car during the incident. So there was a 3-year-old kid, according to the complainant in the car, okay? So when the judge will consider the sentencing, then he will consider about the aggravating factors, and the presence of presence of children is an aggravating factor, okay? And there is a mitigating factor, which is you have no previous convictions. So this means that you are a person of good character. All right. And till now, you have complied with the prosecution. So the judge will also consider that while considering the sentencing. So, in my opinion, a sentence in the region of 1 to 2 years after trial would be a reasonable estimate. However, as the sentence is less than 2 years, there is a chance that the judge might consider a suspended sentence order, which means that the judge will give you a period of time, and in that time period, if you do not commit any further offense, then there is a high possibility that you might not get custodial sentence. All right. So, Mr. Anderson, I just want to ask you, please, could you confirm your plea? Are you pleading guilty or not guilty today?
Not guilty.
Mr. Anderson, assault occasioning actual bodily harm is an either way offense, which means that it can be tried either in magistrate's court or in crown court. Okay. However, it is highly likely that the magistrate's court won't accept jurisdiction and will send the case to the crown court. Okay. Because the magistrate court has the power to sentence for an either way offense for 6 months maximum, and it would be a jury trial in the Crown Court. And juries are lay people, and they are likely to be more representative and persuadable than magistrates. But the trial in Crown Court takes longer. Okay. However, if the court allocates to magistrates court, where would you like to take your trial to be heard? Magistrate court or Crown Court?
What would you advise?
I would advise to go to Crown Court.